His yard drains toward his neighbor's backyard when it rains. Now she's suing him for $25,000 over the flooding. The judge was furious.
My backyard was filled with 7 inches of water last week. I have $4,000 in landscaping damage. My basement is flooded 3 times this year alone.
I've asked him repeatedly to install a drainage system, and he refuses.
$25,000 covers the damage to my property and the modifications he needs to make.
My property has always drained this way. The natural grade has been the same since this neighborhood was built in 1987. I have the original survey right here. I never touched it. My engineer confirmed this is the natural water flow that existed before either of us owned these properties.
All right, Mrs. Coleman, your engineer confirmed the water comes from his property. Did he say Mr. Davis modified his yard to redirect it toward yours?
No, Your Honor, but
When you purchased this property, did your home inspector flag any drainage concerns?
water is still coming from his property and damaging mine.
His natural water flow following topography is not a legal nuisance. He didn't create or modify this drainage pattern. That means unless there's proof of alteration, the law doesn't support your claim. He has no legal obligation to reshape his land to solve a problem that existed before either of you moved here. Case dismissed.
An ex-girlfriend camped on top of a man's Honda Civic, claiming she legally owned him.
He's mine!
Watch her double down before the judge hits her with a reality check.
He said he loved me 3 years ago. That is a legally binding contract of eternal ownership. I have every right to sleep on his car roof until he takes me
Just
back.
needed to go to work. She brought a memory foam mattress and completely caved in the roof of my Honda Civic.
And as his soulmate, my presence is a prized asset.
She was up there eating a whole rotisserie chicken.
He should be paying me for protecting his property. I want compensation for my sunburn.
Ma'am, and I love you is not a property deed, and you are not a roof rack. You crushed a working man's commuter car like a soda can. You owe him $8,000 for a new car.
He's mine! He's mine!
The school called his American flag divisive imagery and suspended him. When he refused to leave, they arrested him for trespassing. Watch the judge give the school board a lesson in the First Amendment.
Once he was suspended for the policy violation, he was no longer allowed on school property. By refusing to drive off campus, he committed criminal trespass. We have a zero tolerance policy for banned individuals.
I didn't trespass, Your Honor. I was sitting in my own truck in the parking lot. The principal told me to take the flag down or leave. I told him I have a First Amendment right to be there, and I'm not moving.
You can't trespass a student for exercising protected speech in a parking lot. That suspension was unconstitutional, which means the trespassing order is void. So I have to dismiss this. And if you tow his truck, I'll charge you with theft.
After utility crews trimmed trees near his property roof, shingles were found broken below. The homeowner says falling branches caused the damage, but the company denied liability. What the judge did next will shock you.
Your Honor, the utility company sent a crew to trim branches around the power lines running along my property line. I was not given advance notice. Later that afternoon, I noticed broken shingles and debris on my roof and in my yard. Several branches had clearly fallen onto the house during the trimming. I contacted the company right away. An inspector came out a few days later and said the damage was unrelated and likely due to normal wear.
Your Honor, our crews follow regulated trimming procedures designed to avoid structural damage. Equipment is positioned carefully and branches are directed away from structures when feasible. Our post-incident inspection determined that the roof exhibited are consistent with aging materials. There was no conclusive evidence linking our operations to the reported damage. Liability cannot be established without definitive proof.
Utility maintenance serves a public purpose. However, that function does not eliminate responsibility for resulting damage. Timing of the roof impact, combined with the debris pattern and the documented condition prior to trimming, establishes a reasonable causal connection. That's the premise. When operations directly affect adjacent property, accountability follows. Judgment is entered in favor of the homeowner for repair costs. Court costs are assessed to the utility.
This truck driver stopped to save a pregnant woman trapped in the wreckage of an accident. The company sued him for late delivery and demanded $85,000 in damages. Watch the judge's reaction.
Your Honor, the defendant was transporting high-value refrigerated cargo. He had a contractual deadline. He stopped for almost 3 hours without authorization. The cargo spoiled. The client canceled the contract. The company regulations are clear. In case of an incident, contact the central office and continue the journey. And he ignored it, and that's why he was fired.
Your Honor, I've been with the company for 15 years. I've never been late with a delivery. Never. That night I saw the overturned car. There was a person inside. A pregnant woman, Your Honor. She held my hand and kept repeating, "Don't leave me here. Save my baby." I just want to ask one question. What should I have done? Left her there to protect the cargo?
Let me see if I understand correctly. The company wants compensation because he saved a life. I have here the medical report of the woman he saved. The doctor stated that another 15 minutes without help would have been the end of both the mother and the baby. The cause of action is annulled, and the company will pay $30,000 in damages to this man. Case closed.